further hearing in the appeals Micula and others against Romania.
Yes. May it please the court, I appear with Mr. Leith for the 2nd to 5th Micula parties, who were previously the respondents and the cross-appellants, and who are now appealing from the order of Mr. Justice Phillips. Mr. Green and Mr. Warboys appear for the first, for Mr. Viorel Micula. Mr. O'Donoghue with Mr. Rothschild and Miss Mackenzie appear for Romania, and Mr. Khan appears for the European Commission, which is intervening in these proceedings as it did in the proceedings below. My lady, my lords, the parties have provided the court with an agreed note identifying the developments that have taken place since the hearing in June that was adjourned, which I hope the court has had an opportunity to read. It's in an additional short bundle. And in brief, the court will have seen that there is now an order of Mr. Justice Phillips extending the stay in relation to the enforcement of the award for the same reasons as those given by the Court of Appeal, and also ordering Romania to pay security. And the court will also have seen that the Micula parties seek permission to appeal on all of the grounds that were raised below against the stay, and also seek permission in relation to a new ground. Unless the court tells me otherwise, what I propose to do is proceed to make our substantive submissions, and I'm assuming for these purposes that the court is content with the issue of jurisdiction, and also content to reserve any issues of permission to the end. But if that's...
I am very bothered that the new appendix, which I have read, doesn't appear to be featuring in the papers that I've got readily to hand. Yeah, that is because they have been buried. It's all right, they were buried. Not your fault.
My ladyship found it.
Happens a lot. Yeah.
So, my lady, may I take it that the court is content for me to proceed and make our substantive submissions?
We don't want to waste any more time, do we? We'd like to get on with the substance of this dispute and see what we can make of it.
My lady, I'm grateful. So in terms of division of responsibility as between me and Mr. Green, I will address the courts on grounds 1 and 2, so whether the English court is required by the 1966 Act to enforce the award, on ground 4, which relates to Article 351, and also on our proposed new ground of appeal. Mr. Green will make some additional submissions on grounds 1 and 2, and will address you on grounds 3, which relates to the European Communities Act 1972. On security, of course, it's Romania that's appealing, and so Romania will open on that issue, and we will respond in due course. And I would like to start with our proposed new ground of appeal, as this does arise from the developments that have taken place since the parties' written cases were filed. And in a nutshell, we contend that in circumstances where the Commission decision has been annulled and the Commission has not sought interim measures staying the effect of the General Court's judgment, there is simply no EU law duty on the English court to stay enforcement of the award. This is a ground that I can develop relatively swiftly, but it's an important ground in our respectful submission, because if we're right, then we would succeed on this ground alone, whatever the outcome of the issues in the other grounds. The courts below, it's necessary in my submission, first of all, to identify what the basis was for the stay in the courts below. The courts below took the view that the EU law duty of sincere cooperation required a stay of enforcement because there was a valid Commission decision which imposed a direct prohibition on Romania from paying the arbitral award to the Micula parties. And so an order of the English court enforcing the award against Romania would have put Romania in breach of the Commission decision. And it's perhaps most conveniently seen in the Court of Appeal's judgment, which you'll find at paragraph 145, and you'll find that at tab 10 of the core volume. And it's memory stick page number 4671. And so at paragraph 145, the Court of Appeal sets out the reasoning of Mr. Justice Blair, and if the court looks at that, and in particular para 132 of Mr. Justice Blair's reasoning, he said that the court cannot therefore proceed to enforce the judgment consequent on registration of the award in circumstances in which the Commission has prohibited Romania from making any payment under the award to the claimants, because in doing so the court would in effect be acting unlawfully. And we see that same reasoning picked up in Lord Justice, that's endorsed in this section of the judgment of the Court of Appeal by Lord Justice Hamblin, and we see it for the court's note also picked up at paragraph 254 of Lord Justice Legate's reasoning, which is MS 4694. I don't think I need to turn it up at this stage. And our submission is that the position is now materially different. First of all, the Commission decision has, of course, been annulled, and so the prohibition it imposed on Romania paying the award no longer exists. And instead, the English court is effectively in the opposite situation, because what we now have is the General Court judgment finding that the Commission did not have jurisdiction to determine that the award constitutes state aid. Now, the Commission could, in principle, have sought interim measures from the Court of Justice, from the CJU, once it had appealed, asking it to suspend the application of the General Court judgment pending the appeal, and it didn't do so. We make that point in our supplemental case at para 35. And it could also have asked the General Court to stay the annulment, stay the effect of the annulment until a future date. We make that point also at para 36 of our supplemental case. But the Commission didn't do that either. And so we say that insofar as the duty of sincere cooperation applies here at all, it's a duty which requires the English court to give effect to the General Court judgment. And so it follows that our simple point under this new ground is that there is no longer any EU law duty at all on the English court to stay enforcement. Romania and the Commission have attempted to confront the fact that the basis for the stay ordered by the courts below no longer exists by putting forward three new different bases on which they claim that the principle of sincere cooperation is nonetheless engaged. And they say this, they say first of all that the suspension injunction of May 2014 has revived and that precludes Romania from paying the compensation. They say second that the Commission's original decision to open the investigation has also revived and that this entails a standstill obligation which precludes Romania from paying the compensation. And thirdly, they rely on the Commission's appeal to the Court of Justice and the possibility that the Court of Justice will quash the General Court's judgment. We say that none of these gives rise to a duty on the English court to stay enforcement of the award, and I will address them in turn. I will address first the suspension injunction and the decision to open the investigation, because very similar considerations arise. There are essentially 2 points. The first point is a point which relates to the injunction, and it relates to the wording and scope of the suspension injunction. Could I ask the court, please, to turn it up? It's in Appendix 1 to the core volume, at tab 10, and it's MS 4749.
For those of us who are looking at it in hard copy, the hard copies don't have those page numbers on them.
I'm so sorry, my lord. I'll give both page numbers. So it's page 117.
Thank you.
That's the start, that's the first page of the suspension injunction. The operative part is at page 128, which is MS 4760. And if the court would read Article 1, you'll see that that's the operative part of the injunction, and it requires Romania, it says Romania shall immediately suspend any action which may lead to the execution or implementation of the award.
The internal number, it starts at 117, but we're at...
I'm so sorry, it's 128. So the beginning, the start of it is 117, and I was going on to the final page, which is 128. As the execution of the award appears to constitute unlawful state aid until the Commission has taken a final decision on the compatibility of that state aid with the internal market. And so the language of this is apt, we say, is expressed to create only an interim prohibition on Romania paying the award. And that prohibition lasted until the Commission took a final decision, which it did. It took that final decision on the 31st of March 2015, 4.5 years ago. And at that point, this suspension injunction ceased to apply. And the annulment of the final decision can't possibly revive the earlier decision. And neither Romania nor the Commission have produced any authority which lends support to any such proposition. Now, I would ask also the court to note in the wording of Article 1 that here what is thought to possibly consider state aid is the execution of the award. And so just to foreshadow a point I'm going to make in due course, there's no attempt here to draw any distinction between those elements of the award that might relate to the period pre-Romania's accession and those which might relate to the period afterwards. So the first point is one on the wording of the injunction. We say it's simply fallen away. The second point relates both to the suspension injunction and to the initial decision to open the investigation, which is also, the Commission says, now revived. And the Commission's argument is essentially that that the General Court didn't annul either of those decisions, and so they remain in force. But that's overly simplistic, and it's wrong, because the difficulty with it is that the earlier decisions are tainted by precisely the same illegality that required the final decision to be annulled. And
because the finding is that there is at least no jurisdiction in respect of the pre-accession period.
That's correct.
At least.
That's correct, my lord. And just to pick up on the point that my lord's made, there is an error in our respectful submission in the way that it's put, at least in Romania's supplemental case, because they proceed on the basis that the court found that there was jurisdiction in respect of the post-accession period, but the court made no such finding. No. And so to the extent they give that impression in their supplemental case, we say that that's incorrect. It's a finding of at least. And so no finding was made on
that's
the
repeated throughout the judgment.
Throughout the judgment.
In several paragraphs. They don't rule that there is jurisdiction in respect of the post-accession period, but they're saying quite clearly there is none in respect of the pre-accession period.
Well, that's right. And one can see, of course, my client's case is that there was no jurisdiction at all. And, my lord, the point is, I might conveniently make it now, is quite a simple one, because the application was brought before the arbitral tribunal before Romania joined the European Union. The application was made in 2005, and Romania didn't join the European Union until the 1st of January 2007. And so when the application was made, that's when our client said their loss crystallised. And so we say that there's no prospect of the Commission ever being able to establish any jurisdiction at all on the reasoning of the General Court. But, of course, my lord's right that point hasn't definitively been decided, or hasn't been decided at all. It's been left open. So, my lord, the simple point is that given that the earlier decisions are tainted by the same illegality, the Commission has a duty to comply with not only the operative part but the reasons of the General Court. We see this, if authority were needed, from Article 266 of the TFEU, which you will find in Authorities 14, tab 196. And there's no hard copy bundle reference, but it's supplemental MS 235. And that says, the first paragraph of that says, that the institution whose act has been declared void or whose failure to act has been declared contrary to the treaties shall be required to take the necessary measures to comply with the judgment of the Court of Justice of the EU. Now, we've handed up another authority, the Asteris case, which you should have in loose copy. And you'll see from that, from paragraphs 20, if I could take you first to paragraph 27. There the court makes the...
Forgive me, Mr. Mitra, I'm afraid I don't... No, is it... Yes, thank you. 27.
27, my lord. So, in order to comply with the judgment and to implement it fully, the institution is required to have regard not only to the operative part of the judgment, but also to the grounds which led to the judgment and constitute its essential basis, insofar as they're necessary to determine the exact meaning of what's stated in the operative parts. And so, it makes the point that it's those grounds which identify the provision held to be illegal and indicate the specific reasons. And then at 28, although a finding of illegality in the grounds of a judgment annulling a measure primarily requires the institution which adopted the measure to eliminate that illegality in the measure intended to replace the annulled measure, it may also, insofar as it relates to a provision with specific scope in a given area, give rise to other consequences for that institution. And then over the page at 29, in cases such as this one, where the effect of the annulled regulation is limited to a clearly defined period, the institution which adopted the measure is first of all under an obligation to ensure that new legislation adopted following the judgment annulling the previous measure and governing the marketing years subsequent to that judgment contains no provisions having the same effect as the provisions held to be illegal. However, by virtue of the retroactive effect of judgments by which measures are annulled, the finding of illegality takes effect from the date on which the annulled measure entered into force. It follows that in the present case, the institution concerned is also under an obligation to eliminate from the regulations already adopted when the annulled judgment was delivered and governing marketing years after 1983-1984, any provisions with the same effect as the provision held to be illegal. And so, turning to the General Court judgment, which is at Authorities 14, tab 215,
Page, please.
yes, so I think we can probably most efficiently pick it up at...
Page, please.
I'm sorry, my lady. Yes, MS 492.
Thank you.
So paragraph 59 sets out the argument, and one just sees there from the heading the Commission's lack of competence and the inapplicability of EU law to a situation predating Romania's accession. That's the argument that's made, and you can see that in para 59, which I won't read out, but just to remind the court of what it was. And the conclusion is at paras 90 to 91, which is on SUP MS 497. And just to recall that the court found there that the amounts at 90, this is at 90, granted as compensation for the period predating Romania's accession cannot constitute state aid within the meaning of EU law. Therefore, it must be held that the Commission exercised its powers retroactively in relation to a situation predating Romania's accession to the EU, at least with regard to those amounts. And then at 91, the Commission, the court found that the entire decision had to be annulled because the Commission did not draw a distinction between the periods of compensation for the damage suffered by the applicants before or after accession. And so, given that the Commission had not purported to draw that distinction, the whole decision was unlawful and had to be annulled. And then there's a second ground for the ruling where that begins, the analysis of that starts at paragraph 94 on the same page, and the conclusion is on page MS 499 at 108 through to 111, and I'm not going to read those out. Essentially, the reasoning is the same reasoning. Now, precisely the same flaws that the General Court identified in the final decision are present in the injunction. I've already shown you the operative part of the injunction, but also in the decision to open the investigation, because in both of those preliminary decisions, the Commission proceeded on the basis that it had jurisdiction over the whole award and did not purport to draw any distinction between the periods pre and post-accession. I'm going to take the Court briefly to the Commission decision to open the investigation, which is also in Authorities Volume 14 at tab 199. And the page is SUP MS 243, that's the start of the decision. And you see there at the top of the page, the Commission, you see the date, the 1st of October 2014, and then the Commission wishes to inform Romania that it's decided to initiate the procedure laid down in Article 108.2 of the treaty. And then if the Court would turn please to MS 253 and Recital 57, that's under the heading New Aid. And this is essentially the retrospectivity point, which is considered by the Commission, which is the first, as we've seen, of the General Court's two bases for annulling the decision. And we see there at 57 a recognition that the standstill obligation applies only to aid that's put into effect after the treaty enters into force. And that's what's called new aid. And then over the page, on page 254, Recital 58, the Commission considers that executing the award, so the whole award, would amount to new aid in the sense of the relevant legislation, as the decision to execute the award would take place after the entry into force of the treaty for Romania. So you can see there the basis why the Commission thinks that the whole award falls within the scope of its jurisdiction, and that's essentially because the decision to execute it postdates Romania's accession. And then at Recital 59, the Commission expressly rejects the argument that the revocation of the measure, which was the source of the complaint, occurred before the entry into force of the treaty for Romania, and says, for the purposes of state aid law, it does not matter at which time those expenses were incurred. Rather, the decisive point in time is the moment at which the state decides to relieve the undertaking of the economic burden that those expenses constitute. So the Commission has expressly rejected any notion that the award can somehow be divided up into pre and post periods. And then in relation to the second of the issues considered by the General Court, which was whether or not there's an advantage, I don't ask you to read the recitals now because it's similar reasoning, but you will see at recitals 33 to 35 on SUP MS 250 the Commission's view. So it follows that these decisions are tainted by the very same illegality that the General Court identified. They cannot give rise to a duty on the English court to stay enforcement of the award, and that's because they cannot be invoked as a source of a prohibition preventing Romania from paying the compensation. In other words, the Commission can't simply say normal service is resumed, we're going back to square one, and shut its eyes to the General Court judgment. It might have been open to the Commission to attempt to reach new decisions which it thinks are compliant with the General Court's judgment. In other words, it might have been open to the Commission to say we're going to open a new investigation and we're going to restrict it for these reasons to the post-accession period. Now, of course, I've already made the point that we say that that would not be a legally sound basis on which to proceed. But if the Commission had purported to do that, then any duty of sincere cooperation could at the very most only attach to the post-accession period. But the key point, and the simple point, is that the Commission has not said that it's doing that. It's not purporting to proceed now to reach a different final decision which complies with the General Court judgment, or which it thinks complies with the General Court judgment. Instead, it's decided, it's elected to take its chances before the CJEU. And it's certainly not correct. Our simple point is that it's certainly not correct that the duty of sincere cooperation requires the English court to continue to defer to the reasoning of the Commission when we all know that the General Court has said this reasoning is wrong. I'm not going to take it up, but the recent judgment of the United States Court of the District of Columbia, which you have, I'll give you the reference, it's in Authorities 15, tab 231, and the relevant pages are MS 831 to 834. The US Court considered precisely this issue and endorsed the expert opinion before it of Sir Nicholas Forward to this effect, and the US Court accepted our arguments that these earlier decisions don't somehow revive and continue unscathed, as though the General Court judgment had not taken place. I want now to consider briefly the third of the bases on which Romania and the Commission say that the duty of sincere cooperation continues to bite, and that's the pending appeal against the General Court judgment to the CJEU. And we can see how the point is put at paragraph 11 of Romania's supplemental case, which is in Core Volume 2, tab 12, Sup MS page 9. This is paragraph 11. So Romania says, a further risk of conflict is that the GCEU judgment may not stand. On the 27th of August 2019, the Commission appealed the judgment to the CJEU. The Commission decision may yet be vindicated. It has not been suggested and cannot fairly be suggested that the Commission's appeal has no realistic prospect of success. And you see then that Romania relies at paragraph 13 on a particular passage in the court's judgment in the Masterfoods case, which I'm going to come to in a moment. And you see there the passage which they say is unambiguous as to the duty in these circumstances on the national court. So that's how Romania puts its argument. But we say that the present circumstances are very different to those in Masterfoods, and that's essentially for two reasons. The first reason, I think it may be helpful for the court to have Masterfoods open. It's at Authorities, Volume 7, tab 100. First page is on MS 1844. That's the start of it. The first, I'll make my points and then take you to the relevant parts in the judgment. The first material distinction between the present case and Masterfoods is that in Masterfoods there was a valid Commission decision. And we see that starting from the facts which are set out at the beginning of the judgment. And if we start at paragraph 3, which is MS 1847, we see the essential facts set out there and in the following paragraph. So HB, which is part of the Unilever Group, is an ice cream manufacturer. And for a number of years, this case concerned its practices of supplying ice cream retailers with freezer cabinets free of charge or at a nominal rent, provided that they are used exclusively for HB products. So that was they had freezer exclusivity clauses in their agreements with the ice cream retailers. And then what happened is that Masterfoods, which was a competitor manufacturer of ice creams, came into the market and started persuading retailers to stock its products as well in the Unilever freezers. And Unilever HB demanded that the exclusivity clause be complied with. We see that from paragraph 5. In paragraph 6, in March 1990, Masterfoods brought an action before the High Court in Ireland seeking a declaration that the exclusivity clause was null and void under the treaty's competition provisions. And then, for its part, HB brought a separate action for an injunction to restrain Master Foods from inducing retailers to breach the exclusivity clause. And you see at paragraph 7 that the High Court granted HB an interlocutory injunction and then gave judgment, this is paragraph 8, in the actions brought by Master Foods and HB respectively, dismissing Master Foods' claim and granting HB a permanent injunction, so effectively finding that the freezer exclusivity clauses were compatible with the treaty's competition provisions. And then there's an appeal, this is at paragraph 9, to the Irish Supreme Court. And then you see from paragraph 10 that in parallel with those proceedings, the Commission then takes this up and investigates it. And over the page, MS 1849, you see at para 14 that the Commission then published its decision on the 11th of March, or made its decision on the 11th of March 1998, finding that these agreements did infringe the competition rules. So there's a difference between the judgment of the Irish High Court, which is then on appeal, and the Commission decision applying what's now Article 101 to the very same agreements. And we see that in those circumstances, the reference was made, and we see the material question at paragraph 18 on MS 1851, and it's really question 1A. So in the light of the judgment and orders of the High Court and the decision of the Commission, does the obligation of sincere cooperation with the Commission require the Supreme Court to stay the instant proceedings pending the disposal of the appeal to the Court of First Instance, now of course the General Court, against the decision of the Commission and any subsequent appeal to the Court of Justice? And it was held that the paragraph relied on by Romania is paragraph 52, which is at page 1861. So, of course, in this case, that the action for annulment was pending before the General Court. It hadn't yet ruled. And we see at para 52, this is the paragraph relied on by Romania. So this is page 1861. It's even more important. So starting perhaps with 51, para 51, it recalls the delimitis judgment, which held that in order not to breach the general principle of legal certainty, so that's, I just emphasise the words legal certainty, this is the rationale for the principle, national courts must, when ruling on agreements or practices which may subsequently be the subject of a decision by the Commission, avoid giving decisions which would conflict with a decision contemplated by the Commission in the implementation of the competition provisions. And then at 52, it's even more important that when national courts rule on agreements or practices which are already the subject of a Commission decision, they can't take decisions running counter to that of the Commission, even if the latter's decision conflicts with a decision given by a national court of first instance. And then at 57, on the next page, 1862, when the outcome of the dispute before the national court depends on the validity of the Commission decision, it follows from the obligation of sincere cooperation that the national court should, in order to avoid reaching a decision that runs counter to that of the Commission, stay its proceedings pending final judgment in the action for annulment by the community courts, unless it considers that in the circumstances of the case, a reference to the Court of Justice for a preliminary ruling on the validity of the Commission decision is warranted. And so I've made my first point, which is that a material distinction between this case and the present case is that, of course, in that case, the decision was valid. And the second point of distinction relates to the nature of the alleged conflict. Because as the court's just seen, in Master Foods, the National Court was seized with precisely the same issue of law as had been addressed by the Commission in its decision, namely the application of the community competition provisions to precisely the same contracts, precisely the same agreements. And so what the European Court was concerned to avoid was a direct conflict on the question of the application of the EU competition provisions to those particular agreements and practices. And we've seen from para 51 of the judgment that I emphasise to you that the reason it was concerned about such a possible conflict related to legal certainty, concerns about legal certainty. And it's not hard to see why there should be such a concern in that case, because it was quite possible that the Irish Supreme Court would endorse the reasoning of the Irish High Court and give these agreements a clean bill of health in circumstances where there was an active and valid Commission decision finding precisely the opposite. And so there would be then diametrically opposed judgments on the same point, or findings on the same point of EU law, which would be highly undesirable in terms of protecting legal certainty. But in the present case, by contrast, there is no such conflict, no risk of that type of conflict, because enforcement now of the award by the English court would not entail any conclusion whatsoever about the application of the state aid rules. So nobody is asking, in enforcing the award, the English court to determine whether this award or any part of it constitutes state aid. And so there's no risk of conflicting judgments of the English court and the Luxembourg courts on that point of law, or indeed on the application of EU law more generally. And so there's no risk of any breach of the principle of legal certainty. So all that would happen is that the award could be enforced, which might result in Romania paying compensation to the Micula parties. And if down the line the CJEU were to reverse the General Court judgment, then at that stage the decision would be valid, the Commission decision, and there would be an obligation on Romania to recover those funds. Now, this wouldn't entail any conflict. It's at most a practical inconvenience, a possible practical inconvenience. Possible because, of course, there's every prospect that the Court of Justice may endorse the reasoning of the General Court, but taking the Romania and the Commission's case at its highest, if it does reverse the judgment, all you have is a need to unravel some practical arrangements. There's no difficulty or obstacle placed in the path of legal certainty. And we say that that possibility of having to unravel the practical arrangements of paying the money, where the money sits for this interregnum, might fairly, we say further, be characterised as remote, because even if the Commission did succeed on its appeal, the matter would then have to be remitted to the General Court to resolve the other grounds for annulment relied on by our clients, which the General Court did not, it was not necessary for them to address because they'd annulled the decision on the grounds that it did. And so there could then be a further appeal to the CJEU on those points, whichever way it goes. And so what one's looking at now in terms of this risk that is asserted by Romania and the Commission is something which may be very, very remote indeed and take a very long time to resolve. And ultimately, we say, is not a risk of the master foods type.
See, the American court took a very robust approach to this.
It did.
I mean, it emphasised the period of time that had elapsed since the ICSID tribunal entered its award in your favour, and pointed out the Commission, in taking an appeal, hadn't sought to suspend the General Court's decision, and said the Court isn't prepared to delay confirmation any longer based on the mere possibility that the CJEU, at some undefined time in the future, might reverse the General Court's decision.
Yes, and those are precisely the points which I'm endeavouring to put to the court. This has been a very, very long time in the making. The application, as I've said, by my clients to the ICSID tribunal was made in 2005. And one can see that even if the Commission, of course, if the Commission fails in its appeal, then any stay will have been completely pointless. And I think nobody is suggesting that the CJEU is likely to resolve this in any shorter period of time than about 2.5 years. That seems to be what the Commission's best estimate. And so 2.5 years, we're then into 2022, which is a very significant period of time after this award has been made. And essentially our key point is that there may be no conflict at all. If there is a conflict, then it's not one which is going to crystallise for a much longer period of time, because the CJEU judgment would not be the end of the story. There'd have to be a remittal and possibly, probably, subsequent appeals, whichever way those go. And so we could be looking at a decade or more, which is an extremely remote and contingent basis on which to impose a duty of sincere cooperation on this court to avoid doing what is its duty, we say, under the ICSID Convention and the 1966 Act. So, my lady, my lords, with that, that's all I wanted to say about our new ground. Obviously,
can I just ask you,
yes, of
your
course.
new ground was accepted by the US court, and you now hold a judgment for $332 million,
Yes.
which I think was the whole amount of the award.
Yes, and so if my lord's implicit question is why are we bothering with the English proceeding?
Well, I'm just wondering how it relates to what's going on in this country.
So my lord, of course, it's one thing to attempt to enforce an award in the courts of any of the contracting states, and it's quite another thing to actually get any money, because once one gets to the execution part, so obviously the hope is that Romania will simply comply with the order of any foreign court requiring it to pay this money. But if it doesn't do so, then one needs to take execution measures, and then one can see down the line possible claims of sovereign immunity and so on and so forth. It rather depends on what assets Romania has within the jurisdiction. We've tried to find that out in relation to the jurisdiction here and have had no success. And so my clients have no option other really than to spread their net quite widely. My lady, my lords, I'm going to turn to grounds 1 and 2 now. And the court will have seen that the Court of Appeal by a majority rejected Romania's argument that the 1966 Act permits a stay of enforcement of an ICSID award. And the majority held that such a stay would be contrary to the ICSID Convention and the 1966 Act. And of course, we agree with that conclusion. However, there was a sting in the tail because the court then went on to conclude that the stay that it ordered in this case is not properly characterised as a stay of enforcement, but a temporary stay of execution, which it found the Act does permit, subject to certain conditions. And the nub of our grounds 1 and 2, which I'm going to deal with together, as I have done in our written case, is that this conclusion was wrong, because the stay granted by the Court of Appeal is not, on proper analysis, a temporary stay of execution, but is properly characterised as a stay of enforcement which the court had no power to order, and which the majority of the court accepted it had no power to order. I'm going to first of all briefly address why the majority of the court below was correct to find that the ICSID Convention and the 1966 Act do not permit the courts to stay enforcement of an ICSID award. And I'm going to address this point both because it sheds light on the subsequent question of why the stay that was actually ordered contravenes the Convention and the Act, and also because Romania urges this court to accept the reasoning of Lord Justice Hamblin, who dissented on that point. And the court will recall that Lord Justice Hamblin, in common with Mr. Justice Blair at first instance, found that it was open to the court, to the English court, to stay enforcement because of a principle of equivalence. So they considered that if the court has the power to stay enforcement of a domestic judgment, that's the limits of the obligation also under the Convention and the 1966 Act. So all that's required for a national court to do is treat an award as being equivalent in its effect to a domestic judgment. But that was rejected by the majority of the Court of Appeal. And our submission, before I turn to open our appeal on the materials, our submission in a nutshell, in response to Lord Justice Hamblin's reasoning, is that it's inconsistent with both the terms and the purpose of the Convention, which are to preclude any substantive bars, any substantive challenge to enforcement of the award. And standing back, it would mean, for example, that an award made in favour of an investor against, say, Zimbabwe, which I've checked is a contracting party to the ICSID Convention, could not be enforced if it could be established that it contravened some provision of the Zimbabwean constitution, or even if an analogous Zimbabwean judgment would not be subject to enforcement because of some emergency act adopted by the Zimbabwe government. So it would open up the doors to all sorts of substantive challenges in all sorts of countries, in every contracting state, and we say that that cannot be right. I'd like to turn first to the ICSID Convention itself. In Authorities Bundle 1, tab 6, MS 81. MS 81 contains the preamble. And towards the bottom of that page, you'll see in the preamble this: recognising that mutual consent by the parties to submit such disputes to conciliation or to arbitration through such facilities constitutes a binding agreement, which requires in particular that due consideration be given to any recommendation of conciliators and that any arbitral award be complied with. And then we have section 6 of the Convention, which begins at MS 97. And I'm going to start. So this section 6 is entitled Recognition and Enforcement of the Award. And Article 53.1 says expressly that the award shall be binding on the parties and shall not be subject to any appeal or to any other remedy except those provided for in this convention. Each party shall abide by and comply with the terms of the award except to the extent that enforcement shall have been stayed pursuant to the relevant provisions of this convention. And so the first point we make is that it's plain from that provision that this is meant to be a complete code and that the only remedies which are permissible under are permissible in respect of an arbitral award are those contained in the convention itself. And we can see what those are if we turn back to section 5, starting on MS page 95. We see there that these are the provisions, Article 50, 51 and 52, which permit awards, permit substantive challenges to awards. So Article 50 permits a request for interpretation of the award. Article 51 permits a party to request revision, for example, where some fact is subsequently discovered which decisively affects the award. And then Article 52 provides for an application for annulment of the award on specific grounds, and the court can see the specific grounds under Article 55.1. They're listed at A to E, and they include, for example, at B, that the tribunal has manifestly exceeded its powers, at D, that there's been a fundamental departure from a fundamental rule, a serious departure from a fundamental rule of procedure, and C, corruption. So the court has the grounds there. And at subparagraph 5 on MS 90, page 97, the committee may, if it considers that the circumstances so require, stay enforcement of the award pending its decision. If the applicant requests a stay of enforcement of the award in his application, enforcement shall be stayed provisionally until the committee rules on such a request. And so where it says in 53.1 that enforcement, each party shall abide by and comply with the terms of the award except to the extent that enforcement shall have been stayed pursuant to the relevant provisions of this convention, that's the provision that is being referred to. Now, back to page 97 and Article 54. So the corollary of the very clear obligation on the parties in Article 53 is that national courts have obligations to ensure that this primary obligation and duty on the parties is complied with. And those are set out in Article 54. So 54.1, each contracting state shall recognise an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of a court in that state. And so just pausing there, those final words are the words that have given rise to a difference of view in the courts below. And so the question really is, does the reference to as if it were a final judgment of a court in that state allow in substantive challenges to the extent that they're permissible against final judgments of the contracting state. And we say no, essentially for the reasons given by the majority below, because this would cut across the deliberate and clear decision of the contracting parties that there be no substantive challenge to an award outside the four corners of the convention itself. And such a construction would also directly cut across Article 53 and be inconsistent with Article 53(1). Now, returning to Article 54, subparagraph 2 states that a party seeking recognition or enforcement in the territories of a contracting state shall furnish to a competent court or other authority a copy of the award. Each contracting state shall notify the Secretary-General of the designation of the competent court or other authority for this purpose. And then at 3, execution of the award shall be governed by the laws concerning the execution of judgments in force in the state in whose territory such execution is sought. And so our case is that the Convention draws a clear distinction between recognition and enforcement on the one hand, which are automatic at national court level, subject, and that the only exceptions, the only possibilities on which one can bring a substantive challenge are those recognised by the Convention itself, and execution of the award, so the mechanics of enforcing it if it's not complied with, which is governed by national law. And then at Article 55, nothing in Article 54 shall be construed as derogating from the law in force in any contracting state relating to immunity of that state or of any foreign state from execution. And that's consistent with Article 54 because such provisions, national provisions relating to sovereign immunity are preserved, and that's because such provisions are relevant in the context of execution of judgments against sovereign entities. Now, I've made our submission as to why on the language of this we say that we are correct, that there can be no substantive challenge to an award at the recognition and enforcement stage. And I'd just like to test the point this way. So leaving aside for a moment EU law, another basis on which a final domestic judgment can be impugned is where it's been obtained through fraud or collusion. And so if Romania were correct about its interpretation of Article 54(1), then a domestic court could refuse to enforce an award on fraud grounds. And we say that that can't be correct for two reasons which are related. The first reason is that, as I've shown the court, the Convention itself provides a mechanism for raising such a point under Article 51. And indeed, Article 51 and 52. And Article 52(2) sets a limitation period for bringing such a challenge. An application has to be made within 120 days after the date on which the award was rendered. And so the drafters of the Convention accordingly decided that the Convention should be the exhaustive code for determining such points. And if the same points could be raised in a particular contracting state simply because they can be raised in relation to final judgments in that state, that would just drive a coach and horses through the exhaustive code that the drafters of the Convention intended. And secondly, and this is relatedly, we see the intention of the drafters of the Convention. I'm going to take you very briefly to some materials which are set out in more detail in our written case, but the drafters of the Convention deliberately decided not to permit challenges to awards in domestic courts on the basis of public policy. And a contrast may be drawn in this respect between this Convention and the New York Convention, which is given effect to by the 1996 Arbitration Act. I'm not going to make any submissions about that because Mr. Green is going to address court on that, but simply to point out that the drafters of this convention deliberately decided not to go down the same route. And so it would follow that if Romania were correct on its construction of Article 54.1, that a party could resist enforcement of an ICSID award in the English courts on grounds of fraud, despite the fact that there's no public policy provision analogous to the New York Convention, then they would be able to, the party would be able to achieve through the back door something which the drafters of the convention deliberately chose not to include.
But in this case, the whole dispute involving the Commission has actually been considered by the ICSID tribunal, hasn't it, under revision proceedings under Article 52 and rejected.
It has. So it's an even stronger point. So the Commission intervened in the ICSID proceedings and made all of its points before the ICSID tribunal, and they were rejected. And so. And there was as the court has seen, there was an application for annulment of the award brought by Romania, which was also rejected. And so in those circumstances, it's even worse because the exhaustive provisions of the convention have been invoked and used, and because they don't like the upshot of them, they're now deciding to achieve the same thing through the back door, and we say that that can't possibly be right. I'm going to take the court briefly to look at some the leading commentary on the convention, which is that of Professor Schroyer, and we see at I think it is volume 13, tab 193. And it's MS 4115. This is within the chapter on Article 53, and I want to refer the court to paragraph 18 in the first instance. The convention provides for its own self-contained system of review of awards. The idea that this review system should be exclusive was expressed repeatedly in the course of the convention's drafting. We see over the page at paragraph 20, the self-contained, under the heading National Courts, the self-contained and exhaustive nature of review proceedings under the ICSID Convention is one of the Convention's distinctive features. It serves the interest of finality of awards and provides a clear advantage over other arbitration mechanisms. Awards stemming from other arbitration systems are subject to potentially protracted and costly review procedures by the courts of the arbitration forum. And this really goes back to the practical point made, or the factual point made by my Lord Reid, which is we're now many years down the track. They've exhausted their rights to review, to challenge the award within the scheme of the convention. And we now are in precisely the type of protracted and costly review procedure that the drafters of the convention thought that they were avoiding. Now, moving on to, in the same document, to the chapter on Article 54, MS 4152, taking it from midway down paragraph 81, the system of review under the Convention is self-contained and does not permit any external review. This principle also extends to the stage of recognition and enforcement of ICSID awards. A domestic court or authority before which recognition and enforcement is sought is restricted to ascertaining the award's authenticity. It may not re-examine the ICSID tribunal's jurisdiction. It may not re-examine the award on the merits, nor may it examine the fairness and propriety of the proceedings before the ICSID tribunal. And it goes on to make the point that this is in contrast to other non-ICSID arbitration systems. And then at 82, during the Convention's preparation, the principle of finality of awards in the context of their enforcement was by no means uncontested, so there was a debate about it, and gave rise to extensive discussion, and it goes on to make the point that a number of delegates wanted to retain some possibility of a review under local law, and that was rejected. And then at 85, the Convention's drafting history shows that domestic authorities charged with recognition and enforcement have no discretion to review the award once its authenticity has been established. Not even the ordre public of the forum may furnish a ground for refusal. The finality of awards would also exclude any examination of their compliance with international public policy or international law in general. That is the task of the arbitral tribunal. So that's what I wanted to say about the Convention itself. I'm going to turn now to the 1966 Act, which gives effect to the United Kingdom's obligations under the Convention. And the Court of Appeal was unanimous on this point. It concluded that the 1966 Act is to be interpreted consistently with the Convention, so at least in terms of the approach to construction, they took the same view, and that's plainly right. Because the legislation was passed in order to fulfil the UK's duties under Article 69 of the Convention to take legislative measures to give it effect. So the Act is in the same volume, Volume 1 of the Authorities at tab 7 behind the next tab, MS 104. Section 1.2 creates a right to registration of the award in the High Court where a person is seeking recognition or enforcement. And this reflects the intention of the Convention. We say that both recognition and enforcement are automatic. And then at 1.4, the award is to be registered for the pecuniary obligations which it imposes and the reasonable costs of and incidental to registration. And then at 1.5, the only circumstance in which the court can decline to register an award in whole or in part is where the pecuniary obligations have been satisfied. And so we say that the purpose of this provision as regards enforcement is automatically to confer the quality, the character of enforceability on the arbitral award. Moving to section 2, this then addresses the practical effect of the award being enforceable, and its purpose is to give legal force to the award for the purposes of executing it and to provide machinery for that purpose. So we see it 2.1a, that proceedings may be taken on the award, B, that interest is payable, and C, that the High Court shall have the same control over the execution of the award as if the award had been such a judgment of the High Court. So we see immediately that 2.1c reflects Article 54.3 of the Convention. And we say that Lord Justice Leggett and Lady Justice Arden, as she then was, are correct that this concerns the mechanics of execution and does not permit enforcement of an award to be refused or stayed on substantive grounds, because that would cut across section 1.2 of the Act and would be inconsistent with the Convention. Now, section 2.2 of the Act provides that civil procedure rules may contain provisions requiring the court to stay execution of any award where enforcement of the award has been stayed pursuant to the Convention, and may provide for the provisional stay of execution of the award where an application is made pursuant to the Convention which might result in a stay of enforcement under the Convention. And again, we see that that reflects the words in the Convention, and the power of the court to stay enforcement in those circumstances is conferred by CPR Part 62.21, subparagraph 5, which is at Authorities 3, A3, tab 30, MS 360. And essentially that's the rule of procedure which gives effect to the obligation of the English court to register an award and confer on it the legal quality of enforceability. and 62.21.5, which is on MS 361, is the only means whereby the enforcement of the award may be stayed, and that's to give effect to Articles 50 to 52 of the Convention. And so we make the point that the existence of this specific power indicates that there's not a more general power elsewhere allowing the courts to stay enforcement. Now, we do accept, for our part, that the majority of the Court of Appeal were correct to find that the courts have a power under Section 2(1)(c) of the Act to stay execution of an award that has been registered and which has been given the legal quality of enforceability. But such a stay must be consistent with the Convention and its purposes. And the key point is that there can't be any stay of execution on substantive grounds. And we've set out in our written case, and it may be quickest to take it from that, at paras 110 to 111. So this is core volume tab 8, MS 4576. We've set out there the well-established principles according to which the court will exercise or may exercise its discretion under domestic law to grant stays of execution.
What paragraph is that, please?
So it's paragraph 111, which is on internal 42. And really the key point that I wish to emphasise is that on the next page, on page MS 4577 at C, that the discretion is exercised on the footing that the judgment in question was correctly decided in all respects. And so as a matter of English law, what one can't do is ask for a stay of execution of a judgment on the basis that it was wrongly decided. And our key argument is that, in effect, having held, the majority of the Court of Appeal having agreed with us that you can't stay enforcement of an award on substantive grounds, then precisely did that, although they called it something else. That's essentially how we put it. And so we say that, and I'm going to move on to that now. So we say that they felt that in a nutshell, the error of the Court of Appeal was this. The Court of Appeal granted the stay because of the pending proceedings before the European courts. And those proceedings, of course, concern the validity of the Commission decision. And the Commission decision found, when it was valid, that the award is incompatible with EU law. And so the entire premise for the stay was because of the substantive objection to the award and its enforceability, which was being litigated in Luxembourg. And so we say that the stay was, therefore, on proper analysis, granted by the courts below for a reason relating to its substantive enforceability, the substantive enforceability of the award, and not for a reason relating to the mechanics of its execution. And I think I can make my submissions most efficiently by picking up the Court of Appeal's reasoning on this, which is behind tab 10 of the core volume. And I'm going to pick it up from Lady Justice Arden's judgment at para 125, which is page MS 4667. And so the court will see that in the second half of that paragraph, Lady Justice Arden states there that it wouldn't be open to the courts of England and Wales to do more than impose a temporary stay on execution if an award is enforceable. It would seem to me provisionally to be likely to be inconsistent with the ICSID Convention if the courts, by using their own powers to stay enforcement granted by domestic law, could effectively thwart execution of an award which has become enforceable under that convention. So we agree with that, respectfully. And then she says at para 126 and 127 that she considers that there's a limited discretion to stay execution, and then at 127 that it would be appropriate to exercise that discretion, and then the reasons are set out in the following paragraphs, short paragraphs. Paragraph 128 is important because Lady Justice Arden is there accepting, we say. She says that a stay on execution is justified in this case until the resolution of the GCEU proceedings or further order in the meantime for reasons which are neither dependent on those proceedings nor inconsistent with the overall purpose of the ICSID Convention for the reasons given below. And we say that that's important because Lady Justice Arden is there at least implicitly recognising that the reasons for the stay can't, on the logic of the conclusion that she's just come to about not being able to stay enforcement on substantive grounds, be dependent on the European Court proceedings. And we say that's correct. But we say that the problem is that the stay that was ordered was obviously dependent on the European Court proceedings because its very purpose was to wait and see whether the Commission decision was held to be valid or not. And the Commission decision, in turn, presents a substantive objection to enforcement of the award, and it would do so on a permanent basis. So this stay is not concerned with the procedural mechanics of execution. Now, moving on in the reasoning, 129 to 131 set out Lady Justice Arden's reasons for finding that this is an appropriate temporary stay of execution. 129 simply explains the prejudice to the Micula parties arising from the delay. So that's not a reason in favour. And Article 131, in turn, finds that an argument made by Romania was not an argument made by Romania was not a complete answer to the stay. This is the ACMEA point. And so really, the reasons are contained in paragraph 130. This is where Lady Justice Arden's reasons are to be found. And she makes the point in the first part of the paragraph that when the Micula parties made their investments, they were aware that the state aid rules might in the future prevent risks in circumstances that Romania became a member of the EU. But we say, well, that's not a proper reason because that is concerned with the substantive merits of the award. And the reasons for a stay, we say, cannot assume anything other than that the award is valid, binding and enforceable. And then Lady Justice Arden goes on to say that the benefits of execution would be circular at this stage because the decision imposes an obligation on Romania to recover any sums paid out by way of compensation under the award. But the short answer to this point now is that the Commission decision has been annulled, and so there no longer is any obligation on Romania to recover sums that are paid on enforcement of the award. So that potential practical circularity does not arise. Now, the Commission will no doubt say, well, it still does arise because of the suspension injunction and the decision to open the investigation because those have been revived, but the Court has my submissions on those points. But the Court of Appeal's reasoning was flawed, even leaving aside the annulment, the subsequent annulment of the decision, because we say that a stay on the basis that enforcement might lead to circularity would we contend, frustrate the ICSID Convention and is not a stay imposed for the purposes of execution, because essentially the point is this, that it's predicated on a substantive objection to the award. Because the reason why the supposed circularity would arise would be because the decision required Romania to pay back sums that had been paid out, because the award, according to the Commission, infringed EU law. And so, ultimately, the circularity objection depends on the substantive objection made by Romania and the Commission to the award, which we say is a matter which has to be ignored when it comes to any temporary stay of execution. Now, moving on to Lord Justice Legate's reasoning, he agreed with Lady Justice Arden's reasoning, and we see at page 4698 what he says, and he really deals with this at paragraphs 269 to 270 of the judgment. And Lord Justice Leggett says at Paras 269 that the methods available for avoiding conflict haven't yet been exhausted, not least because it's not yet apparent whether there is an irreconcilable conflict between EU law and the UK's international obligations under the ICSID Convention. In particular, there would be no such conflict if the General Court or the CJU on appeal were to annul the Commission decision, or were otherwise to interpret Article 351 in a way which is consistent with the UK giving priority to its obligation under the Convention. And then at 270, I agree with Lady Justice Arden that the point has also not yet been reached at which the UK, in breach of its obligation under the ICSID Convention, is in breach of its obligation under the ICSID Convention if it does not take immediate steps to facilitate execution of the award, in accordance with the power of the court discussed above to control the process of execution. It's open to the court to grant a stay of execution pending the outcome of the proceedings in the European courts. That, in my opinion, is the right course to take in circumstances where enforcing the award would conflict with the Commission's decision, and that decision is currently under consideration. But we say, again, that reasoning is flawed because the logic of the stay, according to Lord Justice Leggett, appears to be that a decision should be put off in the hope of avoiding any potential conflict. But although that was no doubt a pragmatic solution, it's inconsistent with this court's, or with the English court, and therefore the UK's obligations under the ICSID Convention, because the premise for waiting to see if there's a conflict is that it's possible substantively to challenge enforcement of the award. Otherwise, why wait to see if there's any conflict? So, or to put the point another way, if it's impermissible, as we say, to raise a substantive objection to the award, including on EU law grounds, then there's no point in waiting to see if this supposed conflict can be resolved. And we can test the point this way. What if the proceedings in Luxembourg before the General Court had gone the other way, or finally resolved against my clients? Well, then Romania, at the end of that process, would no doubt seek a permanent stay of enforcement because of the conflict with the Commission decision, which on that hypothesis would be valid. And we, for our part, would be saying, well, it's impermissible to have a permanent stay for that reason, because enforcement is automatic and you can't raise substantive objections before the National Court. And so at that point, the question whether or not there is a conflict with EU law and how it's to be resolved would have to be grappled with in any event. Those are the points raised by our third and fourth grounds of appeal. So we say that the effect of the Court of Appeal's stay is simply to defer that decision in circumstances where the delay will continue to prejudice our clients. And the fact, of course, that the General Court has annulled the decision only goes to underline the error, because, of course, if Lord Justice Leggett thought that the conflict at that stage might be resolved quickly, or the question whether there was a conflict might be resolved quickly, we now see from what Romania and the Commission are saying, even now that the decision has been annulled, that this could all take a considerable amount of time. We're not just talking about the CJU's judgment, because then we have the other arguments that are raised. If the Commission does succeed in the CJU, of course, there'll have to be a remittal back to the General Court, and we could be talking about many years. And so, essentially, on grounds 1 and 2, our argument is that our key point in a nutshell is that having correctly found that it's not permissible to stay enforcement of an award on substantive grounds, that's not permissible. We agree with the majority. They were wrong to find that this was anything other than that, because this is far from being a temporary stay of execution to resolve a short-lived practical matter, but actually on analysis, the entire premise for the stay is a substantive objection. Otherwise, it would be unnecessary. So, Mr. Green will have some additional submissions to make about grounds 1 and 2, but in view of that, I'd like to move on to ground 4. And ground 4 arises as follows. If we are correct that the ICSID Convention and the 1966 Act do not permit the courts to order this stay, then Romania and the Commission argue that EU law nonetheless imposes a duty on the English court to override the provisions of the 1966 Act. Now, pursuant to our new ground, of course, which I've already advanced, we say that there's no such duty at all. But if we're wrong on that, we contend that there is, on proper analysis, no conflict between the duty under EU law identified by Romania and the Commission and the court's obligations under the 1966 Act, because that putative conflict is resolved by Article 351 of the treaty. The court will find Article 351 in the first volume of authorities at tab 3, MS 42. And we can see from the first paragraph that rights and obligations owed to non-member countries arising from international agreements concluded before the date that a member state accedes to the EU are not affected by the provisions of the EU treaties. And so, of course, the ICSID Convention is a convention entered into by the UK before it acceded to the European communities. That's common ground. The key question between the parties on the substance of Article 351 is therefore whether the rights and obligations engaged under the Convention in this case entail rights and obligations between the UK and one or more third countries. And there is also a dispute between the parties as to whether that substantive question is one of construction of the Convention and therefore a matter for our domestic courts, as we contend, or whether it's a matter for EU law, of EU law and ultimately therefore for the European courts, as Romania and the Commission argue. Now, Romania and the Commission also argue that the substantive question is already pending before the European courts in the context of the challenge to the Commission decision, and that the duty of sincere cooperation precludes this court from determining it now. The majority of the Court of Appeal, although not Lady Justice Arden, agreed with them on that point. We say that it's wrong. I'll come on to explain why in more detail, but to foreshadow the key points I'm going to make, we say that first of all, the Article 351 issue raised in the Luxembourg proceedings is slightly different. And secondly, and so for that reason, the duty of sincere cooperation does not preclude this court from considering the point. And secondly, even more fundamentally, the question whether obligations are owed to third countries under the ICSID Convention in the circumstances of this case is not a question of EU law, and so not a question on which the English court should defer to the European court. And it's therefore quite unlike the Masterfoods case. Now, of course, the factual context is also now very different, because when the Court of Appeal was considering the matter, there was at that stage every prospect that the General Court would rule quite imminently on the Article 351 issue that was before it, and that was relied on by my clients as a ground for annulment of the Commission decision. But we now know that it hasn't done that, and it now seems like there's every prospect that the point won't be considered at all. It won't be considered at all if the CJU uphold the General Court judgment. If it quashes the judgment, then the matter will be remitted to the General Court, and as I've said, we then have the prospect of many, many years before there's a final determination on the point. So the factual context of this argument is now very different to the context as it was before the Court of Appeal.
Would it have been open to the Commission to invite the CJEU to raise to consider the matter, notwithstanding that the General Court did not?
Yes, my Lord raises a good point. It was open to them,
and they chose not to.
They chose not to do that.
Thank you.
I'm going to start with whether the scope of the UK's obligations under the ICSID Convention is a matter for the UK courts or it is a question of EU law. And it's a fundamental point because it also goes to whether or not there's a conflict point, whether the duty of sincere cooperation bites, because I'll come on to say under that head that if we're right that this is a question essentially of domestic law, then there's no case that there's no authority that establishes that the duty of sincere cooperation nonetheless requires the English courts to wait to see what the European courts have to say about it. And I'd like to just turn up first Romania's written case so we can see how it puts its argument. And this is behind tab 6 of the core volume. And it's paragraphs 181b and 182, MS 4460. I'll find the internal page reference in a moment. So it's internal page 82. And we can see from 181b that Romania identifies as a second legal question, even if the claimants are right as a matter of international domestic law, that the obligation is in some sense owed to all ICSID signatories. The effect of that is that that case does not only involve intra-community relations for the purposes of Article 351, and then they go on to say at 182 that we ignore this second point, but that must be argued, that question must be answered to decide whether Article 351 applies, and that is a question of EU law. And they correctly identify that that was accepted by the majority of the Court of Appeal. We don't accept, I don't think that was accepted by Lady Justice Arden, but anyway. And there's then exerted some of Lord Justice Hamblin's judgment on the point, and you'll see the underlined words there. Even if such a claim, that's a claim under Article 664 of the Convention, which is the jurisdiction provision conferring jurisdiction on the ICJ, even if such a claim could in principle be brought, whether that would mean that this case is not one involving intra-community relations is also in dispute in both these proceedings and those in the GCU, and is an EU law matter. So that's how it's put. But so we say that there are 2 points, effectively, that are being made here by Romania that are wrapped up. The first is Romania's statement that the question whether Article 351 applies is a question of EU law. And we say that that statement is inaccurate because, of course, it's clear that the interpretation of Article 351 is a matter of EU law. But it's not the interpretation of Article 351 is not in dispute in this case. What is in dispute is the application of Article 351 to the case in hand, and in particular to the scope, to the facts, to the scope of the UK's obligations in this case, whether or not obligations are owed to third countries. And we say that that's not a matter for EU law, and this court will be very familiar with the division of responsibility between domestic courts and the European Court in the reference procedure, according to which a provision of EU law, the interpretation of a provision of EU law is a matter for the European courts, but the application, once that interpretation is clear, is for domestic courts, and the court will have seen lots of judgments in which the answer to the national court makes that crystal clear. The second thing that Romania does is focus on the words intra-community relations, as indeed did Lord Justice Hamblin, as though that somehow converts the exercise into the exercise of applying Article 351 to the facts as being one of the interpretation of EU law. But the term intra-community relations isn't used in Article 351. It's simply used as a shorthand in Lord Justice Hamblin's judgment for what's actually stated in Article 351, which is whether there are rights and obligations owed to non-member countries. And that question, we say, is not it's a question of fact in each particular case, which involves construing the international convention or treaty at hand. And it's not a question for EU law, it's a question for the domestic court. And there's a line of CJU authority starting with the Levy case that establishes that this is a matter for the National Court to determine. And if we could take up Levy, please, which is in Authorities Volume 7, tab 98. And just to give the court context, the case concerned an International Labour Organisation convention ratified by France before the entry into force of the Treaty of Rome. And Mr. Levy claimed that the French legislation implementing the convention was inconsistent with the Community Equal Treatment Directive.
Could we have the MS page number?
Yes, so if we could pick it up at MS 1819 at paragraph 12, we see that according to the judgment in Commission Italy, the purpose of the first paragraph of Article 234, that's what's now 351, is to make clear, in accordance with the principles of international law, that application of the treaty does not affect the commitment of the member state concerned to respect the right of non-member countries under an earlier agreement and to comply with its corresponding obligations. It follows that in that provision, the term rights and obligations refer as regards rights to the rights of non-member countries and as regards obligations to the obligations of member states. Then moving on, consequently, in order to determine whether a community rule may be deprived of effect by an earlier international agreement, it's necessary to examine whether that agreement imposes on the member state concerned obligations whose performance may still be required by non-member countries which are parties to it. And then we have the analysis at the end of the judgment, MS 1822, in paragraphs 21 to 22. And we see there, in proceedings for preliminary ruling, it's not for this court, but for the national court to determine which obligations are imposed by an earlier international agreement on the member state concerned, and to ascertain their ambit so as to be able to determine the extent to which they constitute an obstacle to the application of the directive. And then we see the answer, which at 22, which interprets Article 351, but leaves its application, and including critically the question whether the ILO Convention imposed obligations on France vis-à-vis non-member countries to the national court.
Mr. Mitru, does the distinction turn on the basis that if it's an intra-community matter, then the states concerned must have agreed to vary the original treaty obligation?
So I think that may be the origins of the words. I think that Lord Justice Hamblin, in his judgment, was simply paraphrasing the wording of Article 351, which require an analysis of whether, because we were arguing that Article 351 in this case applies so as to resolve any potential conflict, because the ICSID Convention imposes obligations on the English courts vis-à-vis non-member countries within the meaning of Article 351. And Lord Justice Hamblin found that that's a matter of EU law, because in part at least, because the converse of whether or not something imposes obligations on the UK vis-à-vis non-member countries is whether or not the case only concerns intra-community relations, which is the argument that was being put by Romania and the Commission, because they say this is all about current member states of the EU. So the nationals are Swedish, the state is Romania, and the courts are the UK courts. And so this only concerns intra-community relations. And I think that was the origin of the phrase in Lord Justice Hamblin's judgment. The point that we make on Levy is that in that case, the court made it crystal clear that question of precedent fact, if I can put it that way, to the application of Article 351 is a matter for the national court and expressly deferred to the national court. And Levy is not a one-off case. There are several CJU judgments applying this principle, and we've footnoted some of them at footnote 120 in paragraph 131 of our written case, which I don't turn up now. But I would like to take the court to one further authority, which is Evans Medical. And the reason that I'd like to take the court to that is because the Advocate General throws light on the question of why this is so. So why is this a question of national law, international law for the domestic court, rather than being a question of EU law for the European courts. And starting with the judgment itself, so you can see where it ended up. This is behind tab 111 of volume 7. I'm going to take you to MS page 2027, paragraphs 27 and following. But before I get to that, if I could briefly explain the context so that you are aware how it arose. And the context was a decision by the government, by the UK government, granting an exclusive license to a pharmaceutical company to manufacture diamorphine, and also prohibiting other companies from importing the drug. So the government refused import licenses to other companies. And that decision was taken in order to implement an international convention which predated the United Kingdom's accession. And a competitor to the exclusive licensee persuaded the government to change its mind and also to authorise it on the basis that the exclusive licence was contrary to the treaty provision on free movement of goods. And the applicant brought proceedings aimed at establishing that Article 351 meant that the free movement of goods provisions didn't override the scheme of the convention. And we see the result at paragraphs 27 and following at MS 2027. And at 27, the court refers back to the Levy judgment. And then at 28, consequently, in order to determine whether a community rule may be deprived of effect by an earlier international agreement, it's necessary to examine whether that agreement imposes on the member state concerned obligations whose performance may still be required by non-member states which are parties to it, and then it cites Levy. And then at 29, however, in proceedings for a preliminary ruling, it's not for this court, but for the national court to determine which obligations are imposed by an earlier international agreement on the member state concerned, and to ascertain their ambit, so as to be able to determine the extent to which they thwart application of the free movement provisions. And then at 30, it's therefore for the national court to examine whether compliance with the convention in relation to non-member states requires allocations of quotas among the undertakings concerned. And so quite clearly there, the result is on all fours with Levy, and they say, the court is there saying that the question of the ambit of the obligations owed by the member state to non-member countries is for the national court to determine. And we see a helpful, in my submission, explanation of why that is in the Advocate General's opinion, which is in the proceeding, behind the preceding tab 110. And if we could take it up at MS 1998, paragraph 31. And so you see there the argument made by the company, Generic. So they say, well, in this case, there are only 2 member states which are affected. And so this is obviously a similar argument to that being made in this case by Romania and the Commission. And so they say, well, this doesn't engage obligations towards non-member states. And then over the page at 1999, paragraph 33, it's thus first necessary to consider whether the convention forms the basis of obligations imposed on the member states vis-à-vis non-member countries. And then further down in that paragraph, this of course requires an interpretation of the convention, which, as I shall explain in greater detail, is a matter for the national court making the reference. However, I believe that the Court of Justice can itself decide this question without further ado. In the first place, it's already carried out such an examination in previous cases. And so what the Advocate General is saying there is that as a matter of legal principle, this is a question for the national court, but we are able to determine it, to determine the answer, because we've had other cases which have considered it. And then moving on to page 2002, paragraph 39, you see a textual basis for the approach that the court has adopted. It follows clearly from these decisions that in the view of the Court of Justice, the interpretation of international agreements at issue in preliminary ruling proceedings is a matter for national courts. This is also in accordance with the treaty, since Article 177, now of course 234, empowers the court to interpret only community law. Article 177 does not confer any power to interpret international law agreements which member states concluded with non-member countries prior to their accession. And so we see there part of the justification or part of the jurisprudential basis for the court taking this approach. And then at paragraph 42, which is on page 2004, it probably goes without saying that jurisdiction for the court to interpret the convention in the context of Article 177 proceedings also cannot be established by taking the view that the court is here required to interpret Article 351, which is a provision of community law. So here, the Advocate General, and I'll just go on, since the court is undoubtedly entitled to carry out that interpretation, so the argument goes, the interpretation of the convention is no more than a preliminary issue which the court is entitled to discuss. Now that's the argument that's made by Romania. You've seen that in Romania's written case. They say, well, this is all about interpreting Article 351. That's a question for EU law. So really the ultimate arbiter on this point is the European Court. But here Advocate General Lenz is rejecting precisely that argument and drawing the distinction between the interpretation of Article 351 and the prior factual determination, which is a matter for the National Court. And then over the page, at page 2005, on paragraph 44, and it's the end of that paragraph, the Advocate General says that it ought nonetheless to be pointed out that although the court can't, in the context of Article 177 proceedings, give a ruling on the interpretation of agreements entered into by the member states with non-member countries, it does, of course, have the task of interpreting community law. National courts may, for that reason, request the court to give a ruling on whether compliance by a member state with obligations which those national courts have found to exist under a particular agreement constitutes an obstacle to the application of community law. So that's a different point to the one arising in this case. So there the Advocate General is saying that if a national court has decided that obligations are owed to third countries, then of course the European Court can decide whether there's then a clash between those obligations and EU law. And then further on, the Advocate General makes the point that in direct actions, in infringement proceedings, then the court can, so if infringement proceedings are being brought against a member state for failure to comply with community law, and the member state raises as a defence a prior pre-existing international treaty, then of course in the context of those proceedings, that's a matter that, the European courts can grapple with. So we say that the case law is absolutely clear that the question of whether in this case the UK owes obligations under the ICSID Convention to non-member countries is a matter of construction of the ICSID Convention and is a question for this court. It's not a question, it doesn't raise a question of interpretation of EU law. And we say that Lady Justice Arden was therefore correct to conclude at paragraphs 180 to 181 of her judgment below that it's not open to the English court to refer to the CJU any question as to the scope of the UK's obligations under the ICSID Convention. And one only needs to state that in my respectful submission to see that it's correct, because it would be a very odd reference to the European Court if this court were to say, we would like you, European Court, to opine on whether the United Kingdom owes obligations to third states under this convention, which the United Kingdom signed up to before its accession to the European communities. So with that, I'd like to address the substantive question of whether, in fact, this case does engage obligations that the UK owes to non-member countries. And for the court's reference, we deal with this at paragraphs 139 to 144 of our written case. Romania's case is that the United Kingdom only owes an obligation to Sweden as being the country of nationality of the investors in this case. We say that that is wrong. We say that it is clear that the ICSID Convention creates multilateral obligations between its contracting parties, and therefore that the United Kingdom does owe obligations to third countries, including in this case, and relevant obligations in this case arise under Article 54 of the Convention, which I've already taken the court to, which provides that the United Kingdom as a contracting state must recognise the award as binding and enforce the pecuniary obligations. And also arise under Article 69 of the Convention, which I don't think the court's seen, so we might briefly turn it up, in Authorities 1, tab 6, MS 101. So the court will see that Article 69 requires the UK to take such legislative or other measures as may be necessary for making the provisions of this convention effective in its territory. And we say that it's fundamental to the way that the convention operates that these obligations are owed to all other parties. And we agree with respect with the way in which Lady Justice Arden put the position at the end of paragraph 192 of the judgment below. Perhaps we could briefly turn that up. So that's core volume, tab 10, MS 4680. At the end of that paragraph, we see this, the inability to intervene in relation to an award to which it was not party would not appear to stop it, this is a third state, proceeding under Article 64 to bring before the International Court of Justice a dispute as to whether the enforcing state had fully complied with its obligations under the ICSID Convention, for the simple reason that every state has an interest in every other's adherence to its mandatory obligation to enforce awards, and has been given the right on an unqualified basis to bring a dispute before that court. On that basis, even though the current dispute concerns only Romania and Sweden, third countries are involved, and that means Article 351 applies. I should perhaps have taken the court to Article 64, which you haven't seen. So if we could go back, with apologies, to Authorities 1, tab 6, page MS 100, and we see there under the heading Disputes Between Contracting States, any dispute arising between contracting states concerning the interpretation or application of this convention, which is not settled by negotiation, shall be referred to the International Court of Justice by the application of any party to such a dispute, unless the states concerned agree to another method of settlement. So although not conclusive, we say that this provision, this article, contains support for our submission accepted by Lady Justice Arden that the obligations are multilateral obligations, because any dispute arising between contracting parties can be referred by any party.
Doesn't it beg the question whether an obligation is owed erga omnes or not? It's simply saying that when there's a dispute as to whether an obligation's been breached.
Except that on one view it might be said to beg the question. We've addressed that in our written case. If I may, I'll come back to it by reference to the Wimbledon case, because we say, I entirely accept my Lord's point, which is why I said it's not a conclusive point, but we say that it provides an indication. I don't put it any higher than that. And I will, with my Lord's permission, come back to that point in due course. So we make the following points to summarise our position, which we've set out fully in our written case. We say that the scheme of the Convention provides that any particular award may be registered and enforced in the courts of any of the contracting states. And a key purpose of this, as is evident from the travaux which we've referred to in our written case, is to promote confidence on the part of investors and thereby encourage investment. And so if the United Kingdom, in breach of its obligations under Article 54, refuses to enforce an award, the beneficiaries of the award are likely to look towards other states which are not bound by the EU treaties to recognise and enforce it. And so those states have every interest in the United Kingdom meeting its obligations so that they are not put to the substantial expense of enforcing the award themselves, something which would be unnecessary if the United Kingdom had met its obligations. And the court has seen that this is not a remote or hypothetical point, because there are active enforcement proceedings in the United States. And as I said in response to a question put by my Lord Reid, it's not unusual for a litigant to take out enforcement proceedings in more than one state. And so the short point is that if any state doesn't comply with its obligations, that places a burden on potentially all the other contracting states to the convention. So one can test the point this way. So if in the 1966 Act, Parliament had provided that no award was to be recognised or enforced if contrary to public policy, for example, that would represent a plain breach of Article 69, which all contracting states would be entitled to complain of, because of its potential to affect its nationals when they invest overseas. But we say, in effect, the stay that's been imposed in this case is not very different to that, because the basis for the stay is to wait and see what happens in the European proceedings, which, as I submitted to the court under grounds 1 and 2, the premise for such a stay is that those European proceedings may present a bar to enforcement. And so if that's going to be the approach of the English courts, that is a difficult matter, because there will be, and there are, other cases awaiting the outcome of this one, there will be many awards in which there may be an objection raised about a breach of EU law. And if the position of the English courts is going to be, well, we stay those depending to see what happens in Luxembourg, then one can see immediately that that places a greater onus on other non-EU contracting states. Our argument is supported by the travaux préparatoires, and I can perhaps take this from paragraph 142 of our written case, which is core volume tab 8, MS 4590. And we see at paragraph 142, the A, in the fifth session held on the 18th of December 1963, the chairman stated that he did not believe that any state which had acceded to the convention would fail to fulfil its provisions. If it did, other contracting states might take such action as might be appropriate. And then B, the chairman expressly acknowledged that the duty to comply with an award was owed to all other contracting parties, telling delegates a state which did not comply would fail to meet its obligations not only to the investor, but also to the community of contracting states, which would presumably include capital exporting countries from which the losing state could expect assistance. And then we see at C that the purpose, and we footnoted the relevant basis for saying that in the history, in the travaux, the purpose of including Article 69 was to ensure that implementing legislation would be enacted in each of the contracting states. And that duty, of course, arises independently. So that's a duty not only to adopt implementing legislation, but also to take whatever measures are necessary to comply with a state's obligation. And that arises independently of the issue of an award in any particular case. And coming back to the point made by my Lord a moment ago about Article 64, we do rely on the SS Wimbledon case, which is at Authorities, Volume 12, Tab 177, and it begins at MS 3787, perhaps we might pick it up at 3790. So, you'll see at 3790 the applicants and the nature of the dispute are summarised. So the applicants were the United Kingdom government, the French government, the King of Italy, the Emperor of Japan, so the United Kingdom, France, Italy, Japan, and the dispute had arisen between these governments and the government of the German Empire by reason of the fact that the steamship Wimbledon was refused permission to pass through the Kiel Canal. And then we see at 3794 some of the facts. So at the bottom of 3794 we see that it's an English steamship which had been time chartered by a French company. And then at 3796 you can see that the vessel was chartered in the manner indicated, had taken on board munitions at Salonika, consigned to the Polish naval base at Danzig. On the morning of March 21st, 1921, it presented itself at the entrance to the Kiel Canal, but the director of canal traffic refused to allow it to pass, basing his refusal upon the neutrality orders issued by Germany in connection with the Russo-Polish War and upon instructions which he had received. And then the French ambassador requested the German government to withdraw this prohibition, and they did not do that. And then at 3798, halfway down, the first question to be considered is whether proceedings could be instituted by the four governments above mentioned in the terms of the application filed. Now, of course, two of the governments, Japan and Italy, had nothing to do with the facts of the case. And the respondent has left this point to the appreciation of the court. Now, Romania, in its written case, tries to distinguish this authority on the basis that the parties had specifically agreed to refer the dispute to the PCIJ, but you can see here that that's incorrect because the matter was expressly left to be decided by the court. It wasn't agreed by the parties. And then the court has no doubt that it can take cognizance of the application instituting proceedings in the form in which it's been submitted. It will suffice to observe for the purposes of this case that each of the four applicant powers has a clear interest in the execution of the provisions relating to the Kiel Canal, since they all possess fleets and merchant vessels flying their respective flags. They are therefore, even though they may be unable to adduce a prejudice to any pecuniary interest, covered by the terms of Article 386. And again, so there the equivalent clause to Article 64 is set out. And my Lord, Lloyd Jones is correct that there's an element of secularity in relying on the jurisdiction provision to claim that obligations exist. So that's why I don't say that that's a conclusive point. But we do say that it's relevant that it is expressed in such broad terms because it's consistent with the general scheme of the Convention that these are multilateral obligations. My lady, I see the time. I have, after lunch, I have a little bit more to do, but not very much. So I have a few further points on the scope of the duty, and then I have to deal with the alleged conflict, and then I'll hand over to Mr. Green, but I'm doing well in terms of time.
You're doing well, are you? Yes. Well, we haven't interrupted you much, so maybe we'll do better after lunch. Yes. We'll look forward to hearing from you again at 2:00.